According to Section 79 of Contract Act, a guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. There are three parties to a guarantee, including principal debtor, creditor, and guarantor. The duty or liability of a guarantor is to repay the loan when the debtor failed to repay it. Guarantor's liability to perform the principal liability only arises upon default by the principal debtor. So guarantee assumes secondary liability until borrower defaults in payment. According to Section 77 of Contract Act, an indemnity is a contract by which one party promises to save the other from loss caused to him by the conduct of the principal debtor or promisor himself or by the conduct of any other person. There are two parties to indemnity, including creditor and the guarantor. The duty or liability of a guarantor is to repay the loan on behalf of the principal debtor. Guarantor will be primarily responsible to perform the principal debtor's obligation. Guarantor assumes principal liability to perform the principal debtor's debt. The guarantor says to the bank, "Give a loan to the borrower, I will pay you for any loss incurred thereon," or "Let him have the loans, I will be your paymaster." Contract of guarantee is not contract of uberrimae fide. This is whereby contract of uberrimae fide means that the contract is based on utmost good faith, whether all the parties must disclose all material facts. Creditor or bank or debtor are not required under any legal duty to disclose facts to the prospective guarantor. The bank does not need to disclose information regarding the conduct of the borrower's account to the guarantor. There are four situations where guarantor may escape liability. First, mistake as the nature of documents signed. Second, undue influence. Third, misrepresentation. And finally, bank's fiduciary duty to guarantors who are customers of the bank. There are several cases involved in this situation. First, Carlisle and Cumberland Banking Company vs. Bragg, Mackenzie vs. Royal Bank of Canada, and Lloyd Banks vs. Bundy. 5 steps to be taken when taking the guarantee or indemnity. First, check guarantor's financial standing. Second, accept only written guarantee. Third, explain necessary terms and conditions to guarantor. Fourth, must include express provision if guarantee intended to extend to transactions already concluded. And finally, the execution must be attested or witnessed by lawyer and stamped within 1 month. A share is defined as an interest of a shareholder in the company. It is measured by a sum of money which is made up of various rights contained in the contract, for example, common shares and preferred shares. Bank will accept shares of public listed companies which are quoted on Bursa Malaysia, such as Telecom and Tenaga Nasional. There are 5 procedures in taking shares as security. First, borrower to open computerized depository system CDS account with stockbroking company. Second, lender or bank will open nominees pledge securities account NPSA. Third, customer transfer shares under CDS to NPSA. Fourth, bank will value the shares and make offer to customer where the margin of finance is up to 80%. And finally, customer accept credit line and executes memorandum of deposit. Debenture is a legal document acknowledging the indebtedness of the company to the debenture holder, which is the bank. This is a document evidencing a debt of a company. It creates contractual rights for the debenture holder, which is the bank, against the company. It can be done through a fixed charge and/or floating charge on the company's asset. For example, debenture stocks, bonds, notes, and others. There are four rights of a debenture holder in relation to default payment made by the issuer of the debenture, which is the borrower. First, to sue for payment. Second, to apply for foreclosure order. Third, petition for winding up the company. And finally, to appoint a receiver to realize or sell the assets of the company.